This episode of the Signal 51 Chronicles is brought to you by Oscar's Pub, 6323 Kent Bowie Boulevard.
Roxo Media House.
A Signal 51 is police code for an investigation, a law enforcement proceeding that is a systemic and thorough attempt to learn the facts about a possible crime that is complex and whose facts and circumstances are generally hidden, at least initially, behind obstacles that can be coincidental and or man-made. Investigations methods are formal. I'm John Henry, a journalist. My partner is Jake White, a retired Fort Worth police sergeant. And together we examine the difficult cases of law enforcement, both in Fort Worth and around the region. This is Signal 51. The show is designed specifically for a more mature audience. Some of the content is graphic and is not intended for younger audiences. This week on the Signal 51 Chronicles, Pamela Laughlin versus the state of Texas. Was socialite Pamela Laughlin kidnapped on December 16, 1982, as she claimed? Or was she, as police alleged, the mastermind of a conspiracy to kill her estranged husband, John D. Laughlin, the son of an oil man and an air conditioning executive, an executive with considerable assets of his own? 5 months after the alleged kidnapping and subsequent discovery of John's body in southwest Parker County, police began making arrests in his death, caused by 4 .45 caliber gunshot wounds to his back. Laughlin and her hairdresser, Lucky Wright, and perhaps her boyfriend, it's difficult to actually tell, were accused of paying 2 men, Michael Stephen Vera, age 35, and Ronald Ferry, 29, $500 to abduct and kill John Laughlin. All that according to Parker County District Attorney Max Smith. Smith initially said he would seek capital murder indictments against Pamela and Wright, meaning they would be eligible for the death penalty, a charge that can be as useful as a bargaining chip for prosecutors, particularly in a conspiracy such as this. Vera had given a statement about the slaying, according to police. Jeff Kearney, who along with Tom Zachary would ultimately defend Pamela in a years-long process, asserted that the case against Pamela Laughlin, was weak, adding that he believed that, quote, because of the reward, John's parents had offered $50,000 for information leading to solving the case, as well as the position of the Laughlin family, the district attorney had been pressured into taking some kind of action. Said Max Smith, the DA, he's entitled to his opinion, but I don't have any comment. My job is to follow the letter of the law, and that's what I'm doing. All the hallmarks of an open and shut case, you say? Think again. The first order of business for the defense was a change in venue. We actually, as an aside, Jake, we actually have quite a bit of lawyering in this case. I guess there's a reason a case needs 3.5 years to resolve, and that's because of lawyers.
Typical.
Totally typical. But anyway, to that end, we've brought to the magnificent Roxo Media Studios our resident attorney. Notice I didn't say anything about retainer. We don't have that kind of money.
But there's no money?
Our resident attorney, Sean Furkey, who guides us on all the paths of litigation. Sean, good afternoon.
Great to see you guys. Glad to be here.
Thanks for being here, Sean.
Always happy to join you guys.
You mentioned before we got on here, you're down 10 pounds. How in the world did you do that over the course of Thanksgiving?
I tell you what, just stress and chasing kids around, and I don't know. It's a tough way to lose weight, but it's working for me. So I'm not going to change anything.
Well, anyway, the defense spent time on a motion to move the trial out of Parker County, contending, of course, that the media attention, and there was a lot of it, made it impossible for Pamela to receive a fair trial in Weatherford, the county seat. And in the end, the defense got its way. The prosecutor, Smith, dropped his objective to a change of venue. District Judge Harry Hopkins, a gentleman in Franklin Roosevelt's cabinet, Harry Hopkins, and his name will figure prominently in this case. Hopkins announced that the trial would be held in neighboring Jack County. Downtown Weatherford to Jacksboro, the county seat of Jack County, is a drive north of about 45 miles. So, Sean, let's let's talk change of venue issues here.
Okay.
Tell our audience, what are some of the reasons that they do seek a change?
So a lot of times defense lawyers will file a motion for a change of venue if they feel that their client cannot get a fair and impartial trial in that county. So in this case, Kearney and Zachary felt that because of the publicity, whether it was news articles or things on the television or just people talking around town, residents of Parker County, because they may have heard about this, they might have some preconceived notion or beliefs that they would be unable to set aside. And obviously to land on a jury, through the jury questionnaire, both sides, the state and the defense, will question potential jurors, and the jurors have to, prove to both sides that they can be fair and impartial. And I think the lawyer's concern in this case was that because of the publicity, because they had heard about it, that they possibly would not be able to do so. That's really the main reason the defense would file a change of venue is because they feel their client can't get a fair trial.
And whether Parker County in those days is a speck of what it is today,
teeny tiny.
So you're also looking at the size of the potential pool of jurors,
which would have been very small,
and they probably talk about everything at the one of 3 coffee shops in town.
I would imagine so.
Every day. We had a notable, the change of venue case I remember most notably anyway is Colin Davis in 1976 or it must have been 77 when that trial went down, which was moved to Amarillo. And then his subsequent murder for hire charge was moved to Houston like 2 years later.
Did you cover those?
We've got a comedian on board here.
Your basis of knowledge is so vast. I figured you had maybe, I don't know.
I don't think that's what you meant.
Oh.
He's got a fast internet connection.
Yeah, that's right.
Oh, okay.
Good at research.
That's right. And another one that still hasn't been ruled on is the Tatiana Jefferson case, the Aaron Dean trial, as it's being called. We had a gentleman in here a few months back, Francisco Hernandez, noted attorney that I know Mr. Furkey is aware of, that we actually just replayed recently.
Yeah. Well, in that one, look at the world we live in, right? Like, where do you move these to? I mean, the people in this case of Jack County, they have this thing called social media, right? They have a phone in their pocket. I mean, I don't know. This seems like an evolving, or a concept that I don't want to say antiquated, but where do you go?
Yeah, I agree. I definitely think in, the day and age of the internet, regardless of whether you're in Tarrant, Parker, Jack County, anybody can have access to this. So, you can make the argument a lot of times, or, this day and age, especially your defense lawyers filing motions for change of venue as a stall tactic. I think that, that could come into play. Some gamesmanship, allow them further time for discovery.
Yep.
There can be all sorts of reasons to do that.
And I think as we get into this trial, that delay tactics will figure prominently.
That will become a common theme
in the strategy. Speaking of this day and age, do we see more change of venue motions today, or do we see less for that very reason you're talking about? Or what do you think?
I would think there'd be less for that very reason.
Yeah, because there is no,
not that there's less motions filed, but I would think there would be significantly less granted by a judge for that reason, because I think it's a harder argument for the defense to make that due to publicity, because, it's not just, this happened in 82, trial in 83, back then, if you weren't reading it in the Weatherford Gazette or whatever, the Weatherford newspaper, the Democrat, you might not have been aware of it. But, nowadays, I think that'd be a much harder, argument to make to a judge.
Particularly the Dean trial, where that's a nationally known event.
Definitely.
Yep. Well, the Judge Hopkins said he would continue to preside over the trial. Which is typical or atypical? Did the judge usually follow that case, Sean? Or
Yeah, I think that is somewhat common. I mean, I think it's up to the judge, but since he's the one, ruling on the motion, I think it's fairly typical for them to go sit on the bench in whatever county it's moved to once that change of venue motion is granted.
And I may be wrong, but if I remember your conversation with Francisco, the financial aspect of moving these trials, because you're not just taking the judge, right? I mean, you're taking the entire system with you.
Yeah.
So
I think he did note that. And that was an issue in this particular case as well, because again, in part one of this episode of this case, I forget now. I can't remember who it was, but they weren't sure that there was a bondsman who could handle underwriting a $750,000 bond.
Yep,
that's a different area, but that just tells you the size and scope of Parker County versus an urban county. Well, Hopkins went on to say that he's going to preside over the trial, and he said that he did not anticipate any further delays and expects both sides to be ready for the trial on December 5th.
That's interesting. Looking at it from the trial that's supposed to start on December 5th of the year 2022, the Aaron Dean trial.
Well, you're right.
Yeah.
I'll be damned. It's a weird world we live in.
Yeah. Small world or something.
I'm going to go with both. Well, he set the trial date for December 5th, 1983. That's almost exactly a year to the day of John Laughlin's murder. Our man, Judge Hopkins, would prove to be no crystal gazer. Zachary, one of Pamela's defense attorneys, said that Jack County meets with our approval fine. And then he added, confirming what appeared to be the already very adversarial environment of the state versus defense, said, quote, "We're somewhat puzzled by the state agreeing at this date to transfer venue to another county, but then we've been puzzled before. Said Max Smith, I withdrew my objection to the defense motion so that we could spend a minimum amount of time on jury selection and get directly into the case. Jury selection in Parker County would have bogged us down. And bogging down was clearly a strategy of the defense from the very first day. Defense attorneys had requested to question potential jurors individually, which could have stretched out jury selection for weeks. Defense attorneys contended that the publicity surrounding the case tainted the Parker County jury pool and that they needed to carefully question each juror who has heard about the case or who says he's heard about the case. The judge had indicated that he would permit individual questioning if the potential juror admitted having prior knowledge of the case, Smith told reporters. The defense had also hired a jury consultant from Houston. Quote, I just decided it would be easier to go to a county other than Parker County and get on with the business of trying the case, Smith said. The team of Kearney and Zachary, Sean, would you call them quite able defense attorneys?
Some of the best Fort Worth's ever had.
That team suggested that Smith also might be playing it safe because if too many Parker County jury prospects had proved to be biased by pretrial publicity, jury selection would have to be abandoned here and repeated someplace else anyway. And again, back to that point, that would be expensive. Parker County being the mere speck on a map compared to the almost cosmopolitan status it has today as Fort Worth's close neighbor. Parker County was footing this bill. The judge, Hopkins, went on to say that he had no alternative but to transfer the case once the DA withdrew his objection.
So in the meantime, Lucky Wright, represented by the recently passed Jim Lane, struck a bargain with prosecutors, agreeing to plead guilty to conspiracy to commit murder and a 15-year prison term in exchange for his promise to help the state. Vera had also agreed to accept a 30-year prison term in exchange for testifying for the state. Vera admitted he was the trigger man. In their plea agreements, the three men said they conspired to kill John Laughlin. Pamela's attorney, meanwhile, believed, or at least they said they believed, that if Ferry were to testify, he would give evidence favorable to Pamela. Kearney said he believed that Ferry would testify that Laughlin's slaying was Vera's idea and that it was the result of a drug deal that went bad. According to those statements from the three, Wright asked Vera if he would kill John. Vera said in his statement that he shot John after he and Ferry had kidnapped him from Pamela's home in the 4700 block of Briarhaven Road in Fort Worth on December 13th. Pamela had asked her estranged husband to come home to fix a broken door, according to Wright's statement. Earlier in the same day, Wright said in his statement that he gave Vera and Ferry a shotgun and pistol. 3 days later, Pamela reported to Fort Worth police that she had been abducted at gunpoint on Hewlin Street and held for $10,000 ransom. Her divorce was to have been completed the same day.
Can I just jump in here right quick?
Go ahead.
If my ex-missus calls me to fix a door, I'm going to tell her to go kiss my ass.
Don't go.
Oh, yeah.
Don't go. If I had an ex, it's unlikely that she would call me to fix a door. That I can promise you.
There are some advantages to being unhandy like myself.
Yes.
As well. I would never be called on for any sort of
Nope.
Repairs.
Mm-mm.
We all have something in common.
Yeah.
Sorry about that, Jake.
All right. So
Carry on with our case here.
the prosecution would attempt to prove that Pamela hoped to inherit her husband's estate, valued at $500,000, more than $1.5 million today. Pamela ordered the death because John owned most of their property, they said, and had a will that would have left her considerable property in the event he died. Moreover, John had created a trust for his wife that would provide her with $20,000 annually. That's more than $60,000 today, if he were to die. Kearney said the main beneficiary of the estate was the couple's 8-year-old son. I think there are some things that are going to come out in this trial that are going to lead to some head scratching, said Zachary. In other words, the defense planned to take the position that those three were so lacking in credibility that the state couldn't prove the case. Each one of the three had received extremely favorable treatment for what they have claimed to have done, Zachary said. On day one of the trial, prosecutors took the jury through its motive for murder, depicting Pamela as a desperate woman who hired 2 drug abusers to kill her husband out of fear that an impending divorce would strip her of her influence. In particular, she dreaded losing family property, including the house on Briarhaven Road, said Assistant DA Dan Kearney. Only months after the couple's first divorce in 1980, Pamela had remarried John to overcome a, quote, loss of status and wealth, Kearney contended. And this time, he said, she sought to eliminate that danger through her husband's death. Prosecutors also said a friend of Pamela's, Bobby Pierce, introduced her to Wright. Wright later helped Pamela hire 2 men to kill her husband for $500. Ultimately, she began discussing the killing of her husband with Wright, the prosecutor said. Wright supplied drugs and firearms to the 2 men, Vera and Ferry. The original slaying plot that Laughlin and Wright masterminded called for Pamela to stage a breakdown in her husband's Ford Bronco on US 80 near the Parker-Tarrant County line, Kearney said. She was to call her husband and have him killed when he met her there, Kearney said. On December 13th, 1982, Vera and Ferry became confused and drove to Fort Worth. The plot was revised when Pamela called her husband at his West Side apartment and asked him to fix a broken sliding door at the Briarhaven house. After John arrived, Vera, armed with a sawed-off shotgun, forced him into the vehicle driven by Ferry, Carney said. Vera shot Laughlin 4 times and dumped his body about 5 miles southwest of Weatherford, the prosecutor said. Vera and Ferry returned to Fort Worth that night to remove John's truck from his wife's home, and a short time later, the 2 men stole guns from John's apartment, Carney said. Prosecutors said a friend of Pamela, James Gober, donned a ski mask to pretend to abduct her and demanded a $10,000 ransom from Pamela's parents. Pamela and Gober actually spent the night at the Ramada Inn Central in Fort Worth, Carney said. On the morning of Pamela's, quote, escape from her, quote, captor, Gober fired a single gunshot in the air just as Pamela ran behind an Exxon gas station at South Hewland Street and Bel Air Drive. That concluded the faux abduction, Carney said. Gober pleaded guilty to attempted capital murder and received a 9-year prison sentence. Bobby Pierce, he owned the Exxon station.
Interesting. The next day, day 3 of the trial, a bombshell. Hopkins, the judge, declared a mistrial because of an oversight, and it was a significant oversight. The judge who had moved the trial to Jack County had heard the case in that changed setting without prior authority. Hopkins, who usually presides over the 43rd District Court cases in Parker County, lacked approval from the 8th Administrative Judicial District to transfer the case to the 271st District Court in Jack County. Now, Sean, right quick, tell us about this Administrative Judicial District.
So it appears that, and again, I don't know if this is common today, but it appears that this 8th Administrative Judicial District would have been the ones to give, a judge or the court that he presided over the authority to do that. And according to this, because Judge Hopkins did not have the permission or the approval from the 8th Administrative Judicial District, that the transfer was improper.
So it sounds like it'd be something like something the judge might get a clearance before he makes the ruling.
Exactly. Or? Yeah, you would think it'd be something he'd have to run by this Administrative Judicial District before he ruled on the motion to change venue.
Well, according to accounts of the day, Hopkins was indeed required to obtain permission from District Judge Charles Murray of Fort Worth. Murray was the presiding judge of that 8th Administrative District before he could hear cases outside his jurisdiction. According to Murray, he didn't tell me or ask me to make the change. Hopkins declared a mistrial because of his procedural error. The record showed the following. Said Hopkins, "Let the record reflect that it has come to the attention of the court that there has never been a formal assignment filed with the clerk of this court assigning me to the 271st District Court to try this case. And that in the presence of the defendant and the attorneys for the defendant and the state, the court is calling this to the attention of the attorneys." Zachary, quote, "Your Honor, at this time we'd ask for a mistrial." Hopkins, "I have no alternative but to grant the defendant's motion for mistrial. You understand, Mrs. Laughlin, what the situation is, that what we've done up to now has been without authority and to proceed. You understand, Mrs. Laughlin, what the situation is, that what we've done up to now has been without authority and that to proceed on with this trial would be a nullity and that your attorneys are asking to declare that what we've done is a nullity, a mistrial, and that's it. Do you agree with that?" "Yes, sir," Pamela replied. Hopkins continued, "I don't know anything else to do. My apologies. I'm going to apologize to everybody concerned as judge of this court. Max Smith, the DA. No apologies necessary, Judge. Hopkins, the responsibility lies with me." Smith said afterward, "I don't in any way blame the judge. There are many things he has to do to take care of business at home. Our case will stay the same. I'm just disappointed that we can't complete what we started." That courtroom dialogue would become the source of a legal labyrinth played out over the next year. A new trial was scheduled for January 1984, but proceedings ground to a halt while defense attorneys attempted to show that the mistrial and retrial constituted double jeopardy. Double jeopardy, of course, prohibits the government from prosecuting defendants for the same crime twice. Ordinarily, double jeopardy does not occur when defense attorneys request a mistrial, as Laughlin's attorneys did. But if a judge provokes defense attorneys into asking for a mistrial, double jeopardy exists. In other words, defense attorneys claimed in court papers that Hopkins improperly terminated the trial by misrepresenting his error as a judicial one, thereby requiring a mistrial. Kearney said it was later learned that Hopkins needed no formal appointment to proceed with the trial. Once Jack County accepted the trial, it had legal jurisdiction, the defense said. The way he represented it to us is that it would have been a waste of time, money, and effort to try the case since the verdict would be null and void because he didn't have jurisdiction, Kearney said. The Second Court of Appeals, in upholding an earlier ruling, said Laughlin's attorneys had not proved that Hopkins solicited the mistrial request. Said Kearney, the Parker County Assistant DA, it's ludicrous that the mistrial the defense requested constitutes double jeopardy. They got a mistrial, exactly what they wanted. Now then, we're up here delaying the trial by arguing on this appeal. The Texas Court of Criminal Appeals eventually upheld both rulings, meaning the trial could proceed a full year after that original mistrial in Jack County. By this time, Judge Hopkins had voluntarily withdrawn from the case. John Lindsay in the 271st District Court in Jacksboro was the new jurist. However, the case was once again stopped for legal maneuvering. Kearney and Zachary, the defense team, weren't finished yet, or at least by all appearances, taking their case to federal court, seeking the same double jeopardy ruling in the U.S. District Court in Fort Worth. However, Kearney and Zachary eventually decided to drop it and go forward. We're anxious to get this thing going, Zachary said. We've tried the case once before, and we have a feeling she's going to get acquitted. We're ready to go on with the thing. So 8 men and 4 women have been selected from a pool of jurors in Jack County for the second trial. A second trial that had been postponed since February and only to begin in May. Well, there was one more delay, actually. They had Memorial Day to get through. Jake, let's talk about Oscar's Pub for a second. The home base for so many good people on the west side of Fort Worth, the birthplace of the Signal 51 Chronicles. Wasn't far from where we're sitting that Jake and I made our vows. Wait, what? No, where we fashioned the idea of what would become the Signal 51 Chronicles. And it's here, Jake, at Oscar's Pub, that you can drink the tastiest beverages with the friendliest people. Be nice or go home. That's the motto of Oscar's Pub. And that is Oscar's Pub, a true friend to the Signal 51 Chronicles.
Located at 6323 Camp Bowie. In the prosecution's opening statement, Brock Smith of Jack County, now assisting the Parker County District Attorney's Office, laid out the same motive, but with one other detail. So Brock Smith depicted Pamela as a, quote, bored, unhappy woman who had affairs with 2 men. Among them was Bobby Pierce, owner of the Exxon station near the Laughlin's home. Smith told jurors that Pierce introduced Laughlin to Wright, the same Lucky Wright who swore in an affidavit that he and Pamela had paid 2 men $500 to kill John. Quote, soon after she met Wright, she started telling him about how unhappy she was in her marriage, Smith said. The defendant and Wright then began discussing the death of John Laughlin. On the next day, the prosecution called one of its key witnesses to the stand, Vera, who admitted in a sworn statement that he was the trigger man. The defense, once it had its shot at him, began chipping away. In his written statement given to police in April of 1983, Vera said that Wright had threatened to kill him if he did not kill John, But on the stand, Vera said that he had lied to police and that Wright never threatened him. He also told police that he had known Wright for only 3 or 4 years. In fact, he said he had known Wright for 15 years. Kearney, the defense attorney, who questioned Vera for several hours, also got a key admission from the witness. He had never once mentioned Pamela's name to detectives when questioned about his role in John's murder. In all, the defense cited 70 different stories Vera had told police and the jury. The star witness was next, Wright. Wright testified that he was to receive $35,000, what would be about $110,000 today, for his role in killing John. Wright told the jury that he and Pamela had twice planned the murder, once in November of 1982 and again in December of 1982. Wright said that in November of 1982, he made a deal with Vera to kill Laughlin. Wright said Vera agreed to abduct and kill John to pay off a debt to Wright. Vera was supposed to have John killed in November while Pamela was on a Colorado ski trip with her family, Wright testified. She wanted it done before the divorce hearing, Wright said. She felt she wasn't going to get certain things in the hearing. She did not want to lose anything in the divorce. Wright said the first attempt failed, and he and Laughlin met again in December of 1982 to again plan the murder. This time, Vera hired Ferry to help. Ferry, and I can't remember if we mentioned this earlier, pleaded guilty to conspiring to commit capital murder and was serving a 20-year sentence. Wright said for the second plan, he told Vera to meet the Laughlins at a service station on US 80 near the Parker County line on December 13th. Wright said Pamela had arranged for her husband to meet her at the service station where she had staged a car breakdown. However, Wright said, Vera drove to the wrong location.
It's a hell of a hitman, I tell you.
There's a couple of
bumbling.
Yeah, it's amazing. Well, yeah. Pamela, Wright said, called him later that night to tell him Vera never showed up. Wright then testified that he and Pamela agreed she would call John to the Briarhaven house to fix a broken door. Wright said he met Pamela for breakfast the next day and discussed the abduction and killing. Pamela asked Wright if he had killed John. I said, quote, no. She seemed relieved, Wright said.
The next day, Wright returned to the stand with more insight. Pamela's quote-unquote abduction was staged, he said. It was her attempt at cover, an alibi for her husband's killing. The kidnapping scheme was her idea, Wright told jurors. She wanted protection. She was trying to cover her tracks. She wanted people to think the same people who killed her husband had kidnapped her. Wright also confirmed what had been reported in media accounts, that Gober, Pamela's friend, wearing a ski mask, quote-unquote, abducted her. And Pamela also had spent her night in quote-unquote captivity at the Ramada Inn Central in Fort Worth. I think we all know where that Ramada Inn Central is. I think that's the one on I-30 there in East Fort Worth. It's the one that has a perfect view of downtown.
Oh, at I-30 and Beach.
Yeah. There you go. I-30. I think that's Ramada Inn Central.
Yeah.
Well, anyway, Kearney countered that it was actually Wright who orchestrated the kidnapping incident to draw attention away from himself and project it onto Pamela. Kearney, of course, doing his job, muddied the waters further, contending that Wright never conspired with Pamela to have her husband killed. Instead, Kearney said, Wright volunteered to have the Fort Worth executive killed, just as he had offered to have another Fort Worth woman's husband killed. What's this about? Well, Wright told jurors that another friend, Tammy Thornton Bruce, had complained to him about problems she was having with her husband, a fellow by the name of Donnie Bruce. This whole thing makes you never want to be married again. Wright testified that he had offered to, quote, take care of him. Kearney said that Wright only agreed to testify against Pamela because he feared that he would be given the death penalty when he was originally arrested in May 1983. Wright testified that he had also been charged with cocaine possession, unlawfully carrying a weapon, and an add-on marijuana possession. Lucky Wright died in 2009 at age 65. In closing arguments, the prosecutor, Max Smith, said Pamela is, quote, the kind of person who could drop a quarter in a telephone, call her folks, and tell them she's been kidnapped and start a nightmare that's never stopped. Kearney and Zachary, meanwhile, reiterated the content of the conspirator's character. Quote, before you can find Mrs. Laughlin guilty, you have to believe what these witnesses told you, Kearney said, claiming in his final stand that Wright made more than $1 million a year in illegal drug deals. His business, the defense attorney went on, requires that you lie, cheat, and scheme every day. He was the kind of man who carried guns. Is that the kind of man you want to believe? Kearney also reminded jurors that Vera had admitted telling a total of more than 70 conflicting stories. Said Zachary, prosecutors can wave around a shotgun, but it doesn't have her fingerprints on it. They can wave motel receipts, but they don't have her name on them. The 3-week trial ended with this headline: Deadlocked jury terminates Laughlin retrial. The defense's strategy worked. The trial of Pamela Laughlin versus the state of Texas ended in a mistrial after jurors deadlocked at 8-4 for acquittal. Pamela got off on the charge of murdering her estranged husband, John Laughlin. Said one juror, there was not enough evidence to say that she had anything to do with it. The state didn't prove its case. Hazel Hutto, Pamela's mother, said, we're very upset. We're very shocked. How else can we feel? We expected an acquittal. They had no evidence. Zachary said he too wanted a final verdict, but was pleased that most jurors voted in Laughlin's favor. The jury felt like there was no evidence to convict Mrs. Laughlin, and that is the correct application of the law. You always want to conclude something. Lindsay, the judge, declared a mistrial after the foreman, Steve Martin, twice sent him a note saying jurors could not reach a unanimous decision. The jury had recessed at about 10:30 Thursday without a verdict. Jurors resumed deliberations at 9 the next morning, Friday, and sent a note to the judge shortly before noon saying they were deadlocked. The judge instructed jurors to continue deliberating, but was told again at about 3 p.m. that a verdict could not be reached. Another juror said the first vote at 5 p.m. Thursday was 6-6. The second vote taken on Friday morning was 8-4, acquittal, and it remained that way. Nobody gave an inch, that juror said. We could have deliberated for the next month, and the vote would have come out the same. Smith, Max Smith, the Parker County prosecutor, was admittedly surprised and disappointed by the decision. Said Zachary, I don't think this is over. He was right. This sorry tale wasn't over. Smith of Parker County announced shortly after the verdict that he would retry Pamela. The trial this time would take place in Palo Pinto County. However, on the eve of the trial, it all abruptly ended. Pamela accepted a plea bargain, pleading no contest to the charge of conspiracy to commit murder. Her sentence, 3 years probation. The deal struck under Judge David Cleveland meant there would be no record of the plea if she didn't find another husband to kill. Oh, I missed. That's
Typo?
Typo.
It happens.
In reality, what the plea bargain stipulated was that if she obeyed the terms of her probation for 3 years, there would not even be any indication that she was ever associated with any crime, much less charged. If she didn't stay out of trouble, she faced 2 to 20 years. John Denton Laughlin, born in 1947, took 4 bullets to the back. Pamela was given a timeout. While Pamela was merely, quote, in the system for 3 years, her conspirators were serving 15, 20, and 30 years respectively. Now that's called good lawyering. For 8 jurors, 100 suspicions don't make a proof. There was, of course, much more than that. starting with the supposed harrowing abduction that Pamela had no interest in the police actually solving. She quit cooperating with the police investigation almost immediately after she was quote-unquote rescued. And the abductors, so the story was to imply, were possibly the same perpetrators who killed her husband. Zachary said he advised Pamela to accept the plea agreement because there was no admission of guilt, merely that 2 witnesses would testify to her guilt, and it freed her from, quote, the agony of another trial. From our standpoint, Zachary said, at worst, it would have been a hung jury. Who's to say they wouldn't have tried it again? At some point, compromises aren't unreasonable. A spokesman for John's parents said the remedy was, quote, not exactly what we had hoped for. On the other hand, he added, curiously, we don't find any fault with it. As for Smith, the crusader who fought the fight for the state and victim, quote, after interviewing that jury in Jacksboro, we figured out they had severe credibility problems with the witnesses. When they read this, he was talking about the jury, perhaps they'll believe the testimony. So let's talk about that right quick.
Yeah.
This plea bargain. She pleaded no contest to conspiracy to commit murder. That was the same charge that Lucky Wright pleaded out to, and he got 15 years.
Yep.
She got a better deal, obviously.
I think you're correct.
And if she's kept her nose clean for 3 years, there would be no record that she was ever even involved with this, except for the record we're making here, that she was very much involved with it, one way or the other.
Yeah, she probably had, I would assume, Kearney or Zachary, expunge the initial arrest. So, yeah, there'd be no record of it once she successfully served that 3-year probation.
And what the financial incentive, what was that for her? Meaning, what did she get financially out of this deal?
We don't know. We don't know that. I don't know how his will was, what it even said. We don't even know that, but how the estate was settled, I don't know.
I mean, I would think nothing, right? I mean, they were married, divorced, remarried in a short time. I mean,
they were married at least since 1975, divorced in 1980, and remarried
a couple months later, right? Yeah.
Several months later. John, what do you make of this performance by the defense?
Well, I mean, they obviously did a wonderful job to be, arrested and charged with murder, and then
starting with capital murder, and then for it to end up in, I guess what was initially a mistrial, because the judge claimed that he didn't have the proper permission to change the venue, and then a hung jury. I think the state at that point, even though they could have retried her, he was just worn out with it, and she got a great deal, a great offer. I mean, 3 years probation, didn't have to go to jail, presumably successfully served that probation, got it expunged from her record.
And she only had to pay like $500 or $1,000 for this whole thing, right?
Well, she, according to Lucky Wright, she was going to be out $35,000.
$35,000.
Yeah, that's a.
The murder for hire always intrigues me. I mean, what's the odds? I mean, the odds of getting away with a murder are slim to none to begin with.
Yeah.
Right. And then you introduce, I mean, in essence, you introduce another witness or a co-conspirator.
Several.
I mean, it's just that many more people that are going to talk.
And we already know how smart those guys were, and the fact that they, went to the wrong city.
They just really couldn't pull it off.
I mean, now in their defense, they didn't have iPhones back then. Maybe they got confused with the whole, highway system, the east and west directions.
Anybody provide them a Maps-Go?
Yeah, maybe a triptych back in the day. That was
a what?
Triptych.
I've never heard of that.
You've never heard of a triptych? You go to AAA, and my dad used to use these when I was a kid. When we drive to Colorado, and you could get this updated version, of the map. They would reflect any road construction, and you basically, so you wouldn't have the big, obtrusive map. It was basically you could flip the pages as you progress. So yeah,
fancy.
Oh yeah.
But these witnesses, speaking of these co-conspirators, alleged co-conspirators, They're the worst nightmare for for a prosecutor, right?
Absolutely.
A defense's dream.
Yes.
Right.
Yes. Yeah. Anytime you're people that are testifying on behalf of the state have negotiated plea deals, once their credibility comes into question, I mean, it becomes a field day. And I've had the privilege of seeing Jeff Kearney cross-examine witnesses for hours on the stand, and it's amazing. You know, it's amazing what he can, what the web that he can weave and get people to basically admit things that they don't even realize
they did it.
Yeah.
Well, I mean, both those guys we mentioned have incredible reputations. Tom Zachary, God rest his soul, has moved on to the other realm. But Jeff Kearney's still going at it strong.
Still going strong.
This is 40 years ago.
He said he's the best in the city. If I'll tell you what, if my tail were on the line, he'd be the first guy I'd call.
And you mentioned you've seen him up close because you worked for him.
I did. I had the honor of interning at his law firm. Let's see, that would have been the summer of 2002. Summer of 2003 after my second year of law school. And then I worked for him for about a year after I graduated law school. So I had the opportunity and the privilege to see him, try some cases, firsthand. And it's just, not only is he a brilliant man, but just, the way he talks to the jury. I mean, he has them hanging on every word. And it's one of those deals where if I had the script and memorized it verbatim and delivered the same closing argument to a jury, it wouldn't have near the effect. I mean, just the way he just got the gift.
The gift of trying that case.
I think you're right. I mean, if I've got it on the line, that's probably who I'm calling, right? And 40 years late. I mean, imagine now 40 years later. 40 years more experience of other.
He would have been a young pup in 83.
I guess so.
Yeah.
What drives a guy like that? I mean, sticking in it for so long. Just love of the law, the competition.
I think all of it. I mean, he's a very competitive guy. Came to TCU to play football. So,
I didn't know that.
Yeah. He and then went to law school at Baylor, and he graduated. Law school typically takes 3 years, and he didn't have much money at the time. And I remember him telling me, I think he finished law school in like 27 months. He just went straight through.
Holy cow.
So obviously very focused, very motivated. And, he's always the best dressed guy at the courthouse too. I tell you what, he always, looks the part, and just his demeanor and the preparation. I mean, he obviously works his tail off, and he's been fortunate to obviously work with some great lawyers in his career, but he loves to tee it up and go to trial, and he prepares like better than anyone I've ever seen do it. And just the style that he has, he comes across, I think a lot of defense lawyers can come across as slimy, or like kind of used car salesman sort of. And he comes across as very,
no offense to used car salesmen.
Yeah, no offense to used car salesmen.
Quite an honorable living.
But he comes across as very genuine and sincere, and juries, they gravitate toward him. And his, obviously, I think one of the reasons he's been so successful in his career is, the respect he has from prosecutors on the other side and judges on the bench. I mean, I saw on several occasions where he was representing someone where maybe, the evidence wasn't all that great for our client, but because of the reputation that he had built up over the decades, and, prosecutors were certainly be more willing to make better offers to his clients just because of the fear of losing to him at trial.
Is there, this case went to Jack County. And then of course the judge recused himself from Parker County. That's one reason why the prosecution wants some help from the local DAs, right, in the Jack County.
Sure,
because there are some pitfalls of prosecution and defense.
Sure,
working a case in front of a judge they don't know.
Exactly. Yeah, and in front of citizens of that county that the people that a county that they don't reside in, they don't live in. So yeah, I think you'll see that on the defense side too. A lot of times, when they'll try, so when I lived in Austin, when I was a prosecutor in Austin, there were times where, they would, bring or cases that were tried in Fort Worth. They would bring a lawyer, that was familiar with trying cases before that judge.
The
or that
defense
staff.
would.
Yeah, absolutely.
Yeah.
Absolutely. Because you know how the other side thinks. You know how that judge is going to rule. So clearly an attorney that's tried cases in front of that judge, or, a prosecutor that's tried cases against defense lawyer that's familiar with the way the prosecutor thinks, they're going to have an advantage.
What prep time? This case, I mean, there's obviously a number of players involved, if you will, but you kind of brought that up. Going back to Carney, he's well prepared, as in summary what you said. What kind of prep time on like any felony? I hate to say this, a run of the mill murder, a run of the mill felony. How much prep time's involved in that?
Oh, I mean, hours and hours and hours, and obviously, depending on how many witnesses involved, how many statements, depending on, just how many people involved, that's obviously going to affect the prep time and how many witnesses you're going to have to prepare to cross-examine as a defense lawyer. But I mean, hours and hours. I wonder, and a lot of it comes, off the cuff. I mean, you obviously have to prepare ahead of time, but during the trial, based on what a state's witness says on direct examination, you got to be able to think of something on the spot, because they might mention something that you didn't think they might say. And, obviously your cross-examination questioning is going to, follow kind of what they say on direct.
I think when we look at one of the other elements of experience, Parker County then was, like you said, a speck on the map. It wasn't like it is today. It's more of it is just a suburb of Fort Worth. There's no difference between, Fort Worth and Parker County now. It's a sea of rooftops from here to there. So you look at the police experience, right? I don't think murders were abundant in Parker County in 1982. So you've got that element. Kind of reminds me of what's going on with this case in Idaho right now. Mm-hmm. Right? You've got 4 people.
Remind me of this case.
Just a couple of weeks ago, there were 4 college students was at Idaho State, or I don't remember the name of the university.
It was a small rural community in
Moscow, Idaho.
Okay.
Right.
That's Idaho State. I believe that is Idaho.
4
State.
students were found murdered in a house off of campus, and they still, as far as I know, have not found a suspect, have not arrested anyone.
Okay.
Stabbed to death or throat slit or whatever.
So anyway, to your point, a small little.
Yeah. I mean, you look at it, does that same murder in Idaho, you bring it to Fort Worth, or you bring it to Dallas, or, these big cities that are used to investigating murders.
And they have the staff to do it.
They have the staff to do it. I'll give you that. I mean, how, I wonder what the difference is. And much like I said, you've got a big dog in Kearney going up against back then, not now, but back then, investigators that probably weren't used to investigating murders.
Right.
I mean, it had to have been like, you take the analogy of Nolan Ryan throwing against like a 10-year-old, right? I mean, it's that off kilter.
Yeah.
I think that perhaps played a role in some of it as well.
No questions. I mean, someone with that experience and that skill set, going up against a small town prosecutor.
Yeah. I
mean, there's no question that you have an advantage.
And I also think that I'm pretty sure that Fort Worth assisted the Weatherford. I think it might have been Parker. I think it might have been sheriff's deputies in the investigation because they were so overwhelmed by.
Yeah, I would believe that.
Collecting evidence and analyzing it.
And the sheer magnitude of the crime and parties involved.
Right.
Yeah, I mean, you gotta look at that. I mean, who was the victim in the, this wasn't a run of the mill guy. I mean, let's face it.
Right.
So, I don't know. Interesting to say the least.
Jake, tell our listeners where they can find us on the socials.
You got us at Signal 51 Chronicles, Facebook and Instagram, and on YouTube, Signal 51 Chronicles. It is important that they subscribe when they get on there.
Yeah, absolutely. Go to YouTube and subscribe. It's free. Just hit subscribe.
All you got to do is press the little thumbs up button. That's it.
Well, that marks the ending of this episode of the Signal 51 Chronicles, Pamela Laughlin versus the state of Texas. It is my hope and dream that this is the last time I ever think about her. To our special guest, Sean Furkey, our resident attorney, without the retainer.
Let's discuss that retainer again. I know there's a Freudian slip there.
We thank you for your assistance and your insight. And we'll see you again sometime soon.
Sounds good. Appreciate it, guys.
All right, Jake, you and I, we'll see him. Bye.
Later.
Roxo Media House.